I looked up from the page and through Maya's open bedroom doorway. Her bed was neatly made, pillow squared, the mint green blanket folded on top. Faded now. Patched. 11 years old. Everything that had happened began with that blanket. All of it was somehow still organized around it. I set the envelope on the counter. Finished my coffee. Called Sandra. They filed, I said. I know. I received notice yesterday. I've been preparing since you called me about Danielle's visit. Sandra had already compiled our full response. The sealed adoption file. 9 years of monthly emails. The original CPS placement documents. Danielle's notarized affidavit. The recordings. The timeline she'd built, the date Danielle had accessed Danielle's probate records through the county portal, and the date the custody petition was filed. 23 days apart. Everything you need has already been built, she said. We simply need the judge to read it. Here is what Danielle didn't understand about the woman she'd left holding a carrier on a doorstep 11 years ago. I was not the same person she'd left behind. I was the woman who had spent 11 years building something precise and permanent, one recorded call at a time, one email at a time, one notarized page at a time. Every piece was in that binder. Every piece was going to court. If you've ever been dismissed by someone who later realized they dismissed the wrong person, stay with me. Sandra's office was on the 3rd floor of a building 2 miles from the courthouse. Her desk was organized in a way that looked like chaos and functioned like a system. She could retrieve any document within 30 seconds. She pulled my binder from the shelf and set it flat between us. Walk me through every tab, she said. Tab 1, the original CPS intake report from the night of abandonment. Officer intake notes. Roberta Sims's placement assessment. Tab 2, my parents' formal letter, submitted through their attorney during the guardianship hearing. We do not oppose guardianship, but request no further contact regarding this matter. Tab 3, 94 monthly emails sent to my parents across 9 years. Response count, 1. My father, month 7. Tab 4, both recorded phone calls from Danielle. Neither inquiry mentioned Maya's welfare. Both requested money. Tab 5, the involuntary termination of parental rights order. The adoption decree. The sealed record. Tab 6, Daniel Whitmore's sworn notarized affidavit, naming me sole trustee and explicitly excluding Danielle, and both maternal grandparents. Tab 7, Sandra's timeline. Danielle accessed the probate portal on a Wednesday in early autumn. The custody petition was filed 23 days later. Sandra closed the binder. We are not going to perform or argue, she said. We are going to submit this file and let the judge read it. 9 years of documentation against 3 weeks of sudden sentiment. She paused. You built this, Claire. I looked at the tabs in my own handwriting. It's Maya's, I said. Martin Voss took my deposition in a conference room at his firm. Mid-50s. Expensive watch. The kind of lawyer who uses physical proximity as a rhetorical technique, leaning forward when he wanted to make something feel like a closing argument. Danielle was not present. Voss, his paralegal, and a court reporter. He started gently. Ms. Carroll, you love Maya. That's not in question. Correct? You'd agree that a child is generally enriched by knowing her biological family. I'd agree that a child benefits from consistency and from people who actually show up. His approach shifted. Isn't it accurate that you prevented Maya's grandparents from having contact with her? No. I sent monthly communications for 9 years. I have copies of every one. Would you like me to arrange for you to review them? He moved on. Isn't it accurate that you withheld information about Maya's biological father from her family? No. Daniel Whitmore found me. Danielle left without disclosing her pregnancy to anyone, including him. You control a trust worth nearly $300,000. A trust established by Maya's biological father, who chose me as trustee after reviewing his options. Sandra intervened exactly twice. Once on procedural grounds. Once when Voss attempted a line of questioning about my personal finances that bore no relevance to the custody matter. The question that mattered came near the end. Ms. Carroll, have you ever spoken disparagingly about Danielle to Maya? I met his eyes. I told Maya that her birth mother wasn't ready when Maya was born. That is a factually accurate statement. I did not editorialize. Voss's pen went still. His paralegal looked at the table. Sandra told me afterward what she'd read in the room. He had prepared for tears, or anger, or defensiveness. He had received a binder, documentation, and a level tone. While Sandra and I prepared, my mother worked the social circuit she'd maintained for 30 years. She attended church. She organized the autumn fundraiser. She sang in the choir. And she told her version of events to people who had known me since childhood. We were kept away from our granddaughter. Claire shut us out. We are just trying to be a family. It landed for some people. A woman who had known me since childhood looked past me in the supermarket without acknowledgement. 2 choir members whispered when I picked up Maya from daycare. The youth group leader asked, with obvious discomfort, whether things were all right at home. I did not organize a counter-campaign. I did not post online, or write anyone a letter, or go door to door with my binder. I told one person, Dr. Reeves, my supervisor and my friend. She sat across from me in the clinic break room with her coffee and said, "Are you going to correct the record?" "The record I'm concerned with," I said, "is the one being assembled in a courtroom. That's where the facts go." But my mother's narrative had at least one structural crack. A woman named Elsie Donahue, 74 years old, former elementary school teacher, a fixture of the community, who had watched Maya grow up from a distance and babysat her twice during long shifts, cornered my mother after a midweek church gathering. "I have known that child her entire life," Elsie said. "Claire never kept anyone away. You chose not to come." My mother's face went blank the way it always did when someone declined to accept her version of things. "You don't know all the circumstances," she said. "I know what an empty chair looks like," Elsie replied. Maya found out through another child. A classmate told her at recess that his mom said Maya's real mother wanted her back. She came home quiet. Ate half her dinner. Did homework without talking. Bathed without being asked. At bedtime she came into my room instead of her own. She hadn't done that since Daniel died. She pulled the blanket up to her chin. "Mama." "Yeah, baby. Are they going to take me?" I turned toward her. She was 10 years old. Her eyes were Daniel's, same wide-set, calm expression. Her chin was Danielle's, though she didn't know it. Her whole heart was entirely her own. "No one is taking you," I said. "You are my daughter. The law says so. The courts say so. And I say so. All 3 of those things are permanent." She studied my face the way children do when they are deciding whether the adult is telling the truth or telling them what they need to hear. Then she pressed her forehead against my shoulder and was asleep within minutes. I lay in the dark and listened to her breathe. The house was still. Through the window, the porch light cast its small warm circle on the front step. I did not cry. I did not make calls. I lay still and thought about what the petition had actually cost, not me, but a 10-year-old girl who had spent a week worrying that the word real might mean something other than what she'd lived every day of her life. The following morning, I called Sandra before my coffee finished brewing. "Whatever it takes," I said. "I need this resolved." Sandra filed 2 motions that week. The first asked that the sealed adoption records be made available solely for the judge's review, not public, not discoverable by opposing counsel. The second sought to introduce Daniel's notarized affidavit as a posthumous declaration, filed with the trust and witnessed by his estate attorney. Martin Voss objected to both. The sealed records, he argued, were immaterial to a best interest analysis. The affidavit, he argued, was hearsay. The judge reviewed the motions in chambers and granted both. Sandra also filed what she called the timeline exhibit, a single-page document, 2 dates, 1 observation. The date Danielle accessed Daniel Whitmore's probate filings through the county's public record portal, verified by the portal's IP access log, and the date the custody petition was filed. 23 days. Voss requested a continuance. "More time to prepare," he said. The judge denied it. "The child's stability is the court's primary concern. This matter will proceed as scheduled." Sandra called me that evening. "The hearing is 3 weeks out. We have everything we need. And Claire, you've been building this case for 11 years without knowing that's what you were doing. 3 more weeks." After 11 years of showing up, 3 weeks felt like almost nothing. The night before the hearing, I set my clothes out on the bed. Dark blazer. White blouse. Charcoal trousers. Conservative. Professional. Not dressing to impress anyone, dressing to represent what I actually was. A nurse. A mother. A woman who kept records. Maya was asleep by 8:15. I made her lunch for the next day and left a note rubber-banded to the bag. "I love you. Dr. Reeves will pick you up. I'll be home before dinner." I sat at the kitchen table with the binder in front of me. I didn't open it. I'd reviewed it enough times that I had its structure memorized. Instead, I set both palms flat on the cover and held it for a moment. Every tab was a decision I'd made. The CPS report, the night I chose to keep her. The emails, 94 months of reaching toward people who never reached back. The recordings, 2 calls about money, neither about Maya. My parents' letter, no further contact. Daniel's affidavit, a man I'd known less than a year who saw more clearly than my own family what Maya needed. The adoption decree, the afternoon a judge made permanent what I had already decided in a parking lot, 3 years earlier, with Maya asleep in the back seat. I closed the binder. Set it beside my keys. Walked through the house, checked every lock, turned off every light, and paused at the front door. The porch light was on. That same fixture. Same warm ring on the concrete step. I'd been leaving it on for 11 years. Tomorrow I would go back to the same courthouse, where I'd signed the original guardianship papers more than a decade ago. This time I wasn't asking for anything. I was answering for what I'd built. 5 in the morning. My hands were slightly unsteady pouring the water, first time. I held the mug in both palms and drank it at the counter, watching the sky ease from dark to grey. Then I dressed, gathered the binder, and drove to the courthouse. Sandra was waiting at the main entrance in a grey wool suit, her briefcase in one hand and a takeout coffee in the other. She handed me the cup without a word. We walked in. The courtroom was the same room I'd been in 3 times before: guardianship, termination, adoption. Each time I'd left with more permanent responsibility and fewer people calling themselves family. This would be the 4th. Danielle sat at the petitioner's table with Martin Voss. Pale blouse, small earrings, the same ones from my porch, expression calibrated for the room. Hands folded, posture composed. My mother sat directly behind her, rigid. My father was beside her, looking at the floor. I walked past them. Did not make eye contact. Sat at the respondent's table, opened the binder, placed my hands flat on the cover. Sandra arranged her materials. Neither of us spoke. The clerk called the room to order. The judge entered, a woman in her late 50s, silver hair cut short, reading glasses on a thin chain around her neck. She settled, reviewed her bench notes, then looked up. In the matter of the petition for custody modification regarding the minor child, Maya Rose Carroll, I would like to begin with the sealed file. Voss presented first. He called Danielle to the stand. She walked to the witness chair with measured steps, arranged a tissue in her hand before she even sat down. Miss Carroll, Voss began, describe your relationship with Maya. Danielle's voice carried a precise tremor, just enough. She is my daughter. I brought her into the world. I have always loved her. Why did you leave her with your sister? Danielle looked at the judge. I was very young. I was completely alone. The father wasn't aware I was pregnant. My own parents were ashamed of the situation. I panicked. I thought my sister could give Maya stability, while I found my footing. I always planned to come back. Did you try to reconnect with your daughter? Many times. But Claire made clear I wasn't welcome. She controlled access entirely. She cut me out of my own child's life. My mother testified next. Same register, polished grief, practiced helplessness. We begged Claire to let us be part of Maya's life. Every attempt was met with a refusal. She excluded us. That's what happened. My father went last. He held a folded card and read from it in a voice that cracked on 2 words. Family should be together. We want to know our granddaughter. We have always had that right. He looked up once, at me, for 1 second, then back at the card. His shoulders dropped slightly. Not visible from the bench. Visible to me. Sandra did not cross-examine any of them. She made 3 notations on her legal pad, underlined 1, and stood. Your Honor, with the court's permission, I'd like to direct your attention to the evidence. The judge had the sealed file in front of her. She had been reading it while Danielle and my parents testified. Now she opened it fully, adjusted her glasses, and turned pages deliberately. The courtroom was soundless except for paper. Her expression was neutral through the first page, neutral through the second. By the third, something changed, a tightening around her jaw, focus narrowing. She read my parents' letter, the CPS intake report, the termination ruling, involuntary abandonment, served by publication, no response. She read the adoption decree. Then she reached the final section. Daniel's affidavit. She slowed. Her finger tracked along a line near the bottom, the part Daniel had underlined twice. She read it a second time. Then she set the file down, removed her glasses, and looked across the room. At Danielle. At my parents. At Martin Voss. Then at me. Ms. Carroll, she meant me. Is it your understanding that the petitioning parties have reviewed this file and understand its contents? I knew what she was asking. Whether Danielle and my parents understood the weight of what they'd initiated. Whether they had any idea what the file said about them. Your Honor, I said, keeping my voice level. They were present for every documented event in that file. They chose, each time, not to act. The judge held my gaze for a moment. Then she looked at Danielle and her attorney. Do they have any idea what this file contains? I simply nodded. Sandra walked the court through the evidence without drama, without performance. Methodical. Sequential. The way I approach a patient intake. Here is what we know, here is what it means, here is what comes next. The petitioner alleges systematic exclusion, Sandra said. The record disagrees. She presented the email log. 94 monthly communications, sent without exception, each containing a photograph of Maya and a standing invitation. Total responses received from both maternal grandparents across 9 years. 1. She read it aloud. She looks well. She let that sit in the room for 3 seconds. She presented my parents' own letter from the guardianship hearing. Read it in full. We do not oppose guardianship, but request no further correspondence on this matter. She presented the text my mother had sent the night Maya was left on my porch. She read it without commentary. Your sister made this mess. It is not ours to clean up. The baby is your responsibility now. My mother's complexion went the color of paper. She gripped the bench in front of her. Sandra presented both of Danielle's recorded phone calls. In 10 years, she said, the petitioner called the respondent twice. Neither call inquired about Maya's health, education, development, or welfare. Both calls requested a money transfer. She played a 12-second clip from the second call. Danielle's voice, sharp and clear through the speaker, you have my kid. You owe me. Then the timeline. Sandra placed a single printed page on the projector. 2 dates. The day Danielle accessed Daniel Whitmore's probate records through the public county portal. The day the custody petition was filed. 23 days between them. Your Honor, Sandra said, this case is not about a child. It is about a trust account. Voss objected. The judge looked at him over her glasses and said, overruled. Sandra read Daniel's affidavit aloud. All of it. When she reached the final clause, under no circumstances should custody or trust administration pass to Danielle Carroll, the sound in the room changed. Danielle's hands fell from the table to her lap. The judge deliberated without leaving the bench. She did not call a recess. She did not retire to chambers. She picked up her glasses, set the sealed file to the side, and spoke. The court has reviewed the sealed record, the submitted evidence, and the testimony of all parties. The following facts are established. She listed them without inflection. Danielle Marie Carroll's parental rights had been involuntarily terminated 8 years prior, on grounds of willful abandonment, in compliance with state statute. She had not contested the termination. She had not appealed. The adoption of Maya Rose Carroll by Claire and Carroll was lawfully executed, complete, and sealed. All statutory requirements had been met. The petitioner carried no legal standing to seek custody modification. The petition was denied and dismissed with prejudice. Regarding the grandparent visitation claim, the co-petitioners had voluntarily disengaged from the child's life across the full span of her upbringing. The evidence clearly showed the respondent had made consistent, documented efforts to include them. They had declined. The petition's timing, filed 23 days after the inheritance was discovered, raised material concerns about motivation. The visitation request was denied. Danielle was on her feet before the judge finished speaking. Her chair scraped back and hit the rail behind her. That is my daughter. Her voice fractured the quiet. You can't do this. She is my blood. You stole her. She turned and pointed directly at me. You stole everything from me. The bailiff stepped forward. Voss reached for Danielle's arm. She yanked away. This is not finished. The judge's voice cut clean across the room. Remove the petitioner if she is unable to maintain decorum. The bailiff guided Danielle into the hallway. My mother rose and followed, chin raised, expression sealed. My father went last. He stopped at the doorway and turned. One long, quiet look at me across the empty room. Then he walked out. The courtroom cleared, Sandra rested her hand on my arm. It's done. I sat for a moment. The ventilation hummed. The clerk organized papers at her station. The flag in the corner stood still. I picked up the binder, tucked it under my arm, and walked out. The corridor was empty. Danielle and my parents were already gone. No confrontation in the hallway. No final exchange in the parking lot. Only the sound of my shoes on the tile, and the late October light pressing through the glass at the end of the hall. I drove to Dr. Reeves's house, a rancher on the east side of town, front garden, wind chimes on the porch. Maya was sitting on the steps when I pulled up, shoes half-tied, book open in her lap. She looked up when my door opened and was running before I cleared the path. What happened? I crouched on the grass and held her face in both hands. No one is taking you. Not today. Not ever. She wrapped her arms around my neck hard enough to crumple my collar. Dr. Reeves stood in the doorway and gave me a single nod. That was enough. We drove home with the windows down. The air was cool and carried the smell of fallen leaves and wood smoke. October in the foothills, when the ridgeline turns copper, and the light thickens to gold by mid-afternoon. Maya hummed something from school, slightly off-key, something about gratitude. We turned into the driveway. The porch light was on. It had been on when I left that morning, and it was still on now, the way it had been on every night for 11 years. Maya ran up the steps and grabbed the door handle. Come on, Mama. I stood at the end of the driveway for one more breath. Then I went inside. We did homework. Made pasta. Played cards and argued about who was cheating. A quiet, ordinary evening. Ordinary was the entire point. Ordinary was everything. A week later, my mother called. Her voice was flat and cold, the register she settled into when she'd been wrong and needed to assign the cost to someone else. I hope you're satisfied with yourself. This was never about satisfaction, Mom. It was always about Maya. You made this family into strangers. You were strangers the night you shut your door. She hung up. I put the phone down and went back to making dinner. Danielle vanished again. Back to wherever she'd come from. Back to silence. This time the silence was a condition I chose rather than one imposed on me, and that distinction felt important. My father wrote me a letter 3 weeks after the ruling. 3 lines on plain white paper. I should have done more. I know that now. I am sorry. I read it while Maya worked on homework across from me. I didn't show it to her. I folded it and filed it in the binder between the adoption record and the trust documents. I did not throw it away. I did not write back. Some apologies arrived too late to require a reply and too honestly to merit the trash. That Saturday evening, after Maya was in bed, I stood on the front porch. The light was on. Crickets. Cool October air. The ridge dark against a sky full of stars. 11 years ago, I had stood in almost this exact spot and lifted a baby out of a carrier, wrapped in a mint green blanket, left with a 4-line note by someone who couldn't stay. That baby was inside. 10 years old. Safe. Asleep with the same blanket, patched twice, worn thin, loved past reasonable use. Family isn't something you inherit. It's a promise you keep, one ordinary morning at a time. I turned off the porch light. Then I turned it back on. It had become something I didn't know how to explain, that light. A habit, or a vigil, or a way of saying, I am still here, and the door is still on. She came to me wrapped in a blanket, and a 4-line note. She left that courtroom wrapped in 11 years of proof. 94 emails. 2 phone calls about money. 1 mint green blanket, patched and faded. One binder 3 inches thick. One sealed file containing 11 years of evidence that being present matters more than being biological. If you are the person who has ever stayed when leaving was easier, who chose the hard morning over the clean exit, who loved without applause and showed up when no one was watching, this story was always yours. If this moved you, please give it a like. And if you're new here, welcome to Quiet Justice Tales, where we tell the stories of ordinary people who quietly refuse to give up. Subscribe so you never miss one. I'll see you next time.